So now I'm going to move on to our final segment. So I'm going to once again share my screen to introduce our speakers for segment 3. Okay. So for segment 3, our moderator today will be G. Vijay Kumar, who is a partner in Lee Hishamuddin's Allen & Gledhill's market-leading technology, media and telecommunications, and corporate and commercial dispute resolution practice groups. Then we have our speakers who are Thayanathan Bhaskaran, who is a partner with Bhaskaran, Kuala Lumpur, and an associate member of Crown Office Chambers, London. Next, we have Kugun Huat, who is a partner at Screen. And last but not least, we have Adeline Chin, who is a co-founder of 3 legal-related companies, namely Law Tech Malaysia, Law Asia 365, and Cyprus Bookstore. And she is also a steering committee member of the Asia Pacific Legal Innovation and Technology Association. So with that, I will go ahead and pass the floor over to Vijay to go ahead and moderate our final session. Thanks so much.
Thank you, Chelsea. Good morning, everyone. It's been a very interesting session so far. And we have now come to our final segment, and we're going to talk a bit about disputes. I know generally disputes are the last thing on parties' minds when they enter into a contract. However, as any lawyer who's worth his salt will tell you, dispute resolution clauses are actually extremely important. Because when you get involved in a dispute, you want to ensure that there are sufficient clauses that are in place to ensure that your rights are protected, and you knowingly and cognizantly ensure that you are going to resolve your dispute in a forum that you are comfortable with and have confidence in. So in that respect, the SDC has got you covered, because a lot of thought has gone into it by the committee who was involved in drafting the contract to ensure that the clauses that have been put in place are there to ensure that parties have a fair and balanced dispute resolution process in the event they get into a dispute. Now, we have 3 speakers who are very experienced in dispute resolution processes, and we have some questions for them this morning. So without further ado, let me get straight on to a question from Ms. Adeline Chin. Adeline, from your experience, can you tell us and highlight some of the common disputes that may arise between parties in software development contracts?
Sure thing. I think what we commonly observe are mainly 4 kinds of disputes that would arise. And the main one would be misrepresentation, or fraud on part of the vendors. So customers or clients would sue software developers or software vendors frequently based on, say, a misrepresentation of the software functionality, for instance. So because it's a sales pitch, it always is if it's an independent software development house. So when you pitch the sales, when vendors do that, they usually would want to put their best foot forward. And when it comes to the work itself, sometimes the functionality doesn't meet the requirements or expectation of what has been represented to the customer. So misrepresentation of the software's functionality is one of the most common that I've come across. And another one is also misrepresentation of the vendor's capabilities. For software developers would know whether you are a front-end developer, whether you're a back-end developer, and if you are a back-end developer, you use various different languages, you build various different software based on the background that you have experience in. And from there on, that is the kind of capability that you kind of pitch to customers. Let's say you're very, very good at building, say, a payment gateway platform, but you're not very good at building, let's say, a document management platform. So those 2 are very different products. In a sales pitch, vendors may represent that they could build a payment gateway platform that also have document management integration. I don't know whether such a platform exists, but if you can't build it, if you don't have that kind of capability, then a dispute would arise when you are not able to deliver what you promised. So that's one of the dispute that's really common. The second one is something that has been highlighted in our previous session, breach of contract. That is very common. So do read through the terms. The SDC helps you to help consolidate terms that are common in software development contracts. And it's also to put down the terms that you may want to leave open-ended. Now, open-ended terms tend to leave customers and vendors in a position of limbo. So the best thing is to have your terms clearly set out. Take a look at the SDC template, and you can pick and choose the kind of terms that you want to put in or adopt into your contract. So the most common thing to put in would be, say, a term on umbrella licenses, for instance, or service agreement that you can place together with your statement of work. It could be a single sheet of statement of work. It could be multiple statements of work. You could also incorporate your project plan in there, and it's best to definitely put in your schedule for the implementation. And then on the vendor side, it's also good to put in, say, disclaimers, limitations of liability, just in case there are damages or, let's say, excess that are not within your control, so that when there are damages to the software and it is not done on your part as a developer, then it's better to safeguard yourself in that sense. Warranties as well. What are your warranty terms? How long could it be? And what kind of warranty do you provide? So those are good for vendors and for customers. Put down details of your agreement with the vendor or the developer within your contract. The other two common breaches are really quite simple. One is, let's say, a breach of implied covenant. Say the customer and the vendor expect each other to not leak out trade secret, for instance. If you have had that in the conversation before you want to build the contract, or before you want to build the software, or before you even enter into a contract, for instance. So there's a kind of good faith that's involved in your dealing between customer and vendor or customer and developer. And the last one is not too common, but it does happen in jurisdictions where software development, large-scale software development contracts are in existence. So those are violations of consumer protection statutes. And I believe our previous session have touched on that a little bit. So that could be, here in Malaysia, we predominantly use the principal law of Consumer Protection Act, the CPA, and it would protect the consumer in things like, you know, misleading or deceptive conduct, safety of the services provided, for instance. You don't create things that are illegal under Malaysian law, say certain types of gambling, certain types of gaming, prostitution online, things like that, right? So be safe, there's a framework to it. There's some sort of consumer protection statute that's there for you to not breach. Yeah, I think that's all I have. Back to you, Vijay.
Thanks, Adeline. That's very insightful. I think you've touched on the key areas that we have also come across in handling disputes on behalf of our clients. Could I now move on to clause 4 of the SDC? I think this is a key area when it comes to disputes, right? Obviously, when parties get involved in a dispute, then they start looking at what rights they have under the contract. And one of the rights that the SDC gives them is to suspend works under the contract. Can you touch a bit about what rights parties have to suspend works in the event of a breach or any occurrence of a non-compliance of terms under the contract?
I would say suspension of work should be in agreement between the parties. So the parties should agree that they want to suspend work under various circumstances, and the notification to suspend work should be in writing, and that's best, because if there's a breach, then you'll probably go into dispute. Circumstances that you probably could suspend work could be things like a lack of resources, either by the customer or by the vendor, for instance. There can be a lack of funding to further develop the software as promised. There can be a lack of human resource or a flux of human resource in the development of the software. There can also be management changes, for instance, merger or acquisition of either of the companies, be it the developer or the customer. Personnel changes, you could suspend it for a little bit. The second thing would also be a suspension to facilitate, say, a change in the project scope. If there's a change in feasibility or viability of the project based on recent development or recent information on the target market, for instance, then the parties can agree to suspend the project for a while based on whatever you have agreed upon within your contract. It could also be suspension to revise functionality or project scope due to legislative or regulatory changes. For instance, I'm not saying that this happened. You could say that if a local bar association passed a ruling that non-law firms cannot provide template agreements on websites or on digital platforms, or let's say the Bank Negara bans transactions that are payable through cryptocurrency on e-commerce websites. So if your software is one that only allows cryptocurrency as a mode of payment, and if the national bank bans such transactions or such payment mode, then it's something that you may suspend and you want to relook into it. And I think the last one would probably be either severe difficulties in developing or launching or even testing the products. So if you don't have a good enough group to test the product, you could speak to the developer, for instance, or the developer could speak to the customer to say, hey, we'll wait until you get a good group to launch our beta, and then we can do our testing later on, and we'll suspend it for the time being until you get a good group to test it out. These are things that I could think of. I mean, the other panelists might as well chip in.
Thanks, Adeline. That's very comprehensive. Now, we are running out of the time quickly, unfortunately. So I'll straight jump to a question for Taya. Taya, you know, it's very common in software development contracts or variations to occur, right? So one party may want, obviously the customer over the course of the project may want to vary the terms of the contract for whatever reason. Suddenly, maybe they find that some aspect of their business requires some variation to the software that they require from the vendor. Now, can you tell us a bit about what sort of clauses we have in the SDC that allows parties to vary the terms of the contract in terms of project scope and so on under the SDC?
Yes, good morning, Vijay, and thank you to everyone for attending. So with regards to variations, this is expressly provided for in the SDC under clause 9. The clauses have been drafted in such a way to minimize disputes as much as possible. So what is essentially required is that either party, either the developer or the other party, can make a proposal for a variation. And 7 days after that proposal is made, that variation can be agreed to, and a variation agreement can be entered into to reflect that variation that has been agreed between the parties. Interestingly, then the SDC also provides that if a party fails to make a claim for a variation within 14 days of the event in relation to a variation occurring, then they would have foregone that claim for a variation, and the other party will be discharged from paying for that variation. The general trend of judgments from our courts is that these sorts of time bar notice provisions will be enforced by the courts. We have seen them being enforced recently in judgments. This marks a slight shift in the position of the courts. Previously, there was a feeling that these provisions may be contrary to parties enforcing their legal rights, and the courts were quite reluctant to enforce them. But the more reasoned approach has been to allow these clauses to be enforced for the purposes of business certainty. Of course, you know, all variations have both a time and a cost impact. In relation to the time and cost impact, that is also expressly provided for in clause 9 of the SDC. In terms of cost, if there's going to be any increase in cost as a result of the variation or any reduction in cost, then that needs to be expressly set out in the variation agreement between the parties. Again, interestingly, the SDC provides that if cost is simply not dealt with in the variation agreement, then it will be assumed that there is no cost involved and the contract sum will be maintained and will not be changed. And finally, with regards to delay, if additional time or less time is required as a result of a variation, similarly, that needs to be expressly provided for in the variation agreement between the parties. So the essential scheme is that there must be a proposal, an acceptance, and then a variation agreement to reflect that variation, firstly. And secondly, if there is a failure to make a proposal or to claim a variation within a specified time, then your right to that variation is foregone. Yes.
Thanks, Daya. You touched on the issue of delay, which might occur because of the variation, right? So obviously, if there's a variation of the terms of the contract, one would expect that sometimes the project timeline might have to be changed as well. Now, what happens if we are not talking about variation, but as we know, in project situations, there's always this issue of delay. You know, it happens quite frequently. Now, what does the SDC provide in the event that the project is delayed by the vendor? What are the rights that the customer has in such a situation?
Yes, thank you, Vijay. So in that situation, delays are expressly provided for in clause 10 of the SDC. Essentially, the SDC provides that liquidated damages are to be paid if there have been any delays to the performance of the works, the delivery of the deliverables. Two interesting aspects to this clause, which perhaps takes it out of the norm of your standard liquidated damages clause. One is it allows for a proportionate increase of the amount of the liquidated damages. So firstly, the liquidated damages will only be a percentage of the particular part of the deliverables that have actually not been delivered. So that's number one. And then number two, however, it goes on to say if that part of the deliverable is essential and is to work in combination with other parts of the deliverables, then the liquidated damages will apply to the entire part of the deliverables that are to work together and not simply the deliverable part that has not been delivered. So that's the first part of the liquidated damages clause. And then there is a lengthy provision running from 10.2 to 10.4, which, in relation to the queries earlier about clauses needing to be drafted in plainer English, and then the response to that, the various clauses are then drafted to address peculiar legal scenarios. So these lengthy provisions in 10.2 to 10.4 on liquidated damages, they are actually there to deal with the current position in Malaysia with regards to liquidated damages. So these provisions essentially state that there is an express recognition that the liquidated damages are reasonable. There's also an express acknowledgement that damages would be difficult to assess for the customer. And as a result, the loss and expense that has been incurred is accurately reflected in the liquidated damages. And finally, there is an acknowledgement by the developer that they will not contend that the sums in the liquidated damages provisions are unreasonable in any way. Apart from that, apart from what's expressly provided for in the contract, it's also important to bear in mind that liquidated damages provisions in light of Section 75 of our Contracts Act will serve as a limit on the losses that can be recovered by the customer in any particular situation.
Thanks, Daya. Obviously, there's a lot to talk about when it comes to liquidated damages. I don't think we have sufficient time to go into all those legal issues here. Guan Wat, now can I, obviously the cornerstone of a dispute, right, would be when there's a breach, right, by either party. Now, can you tell us a bit about what happens under the SDC, right? Say if one party is in breach of the contract, what rights are provided under the contract for the innocent party? How does he seek a remedy? Are there any provisions specifically tailored for this situation?
Well, essentially, I think when there is a breach, I think one of the first things to consider is whether the innocent party wishes to terminate all relationship with the other party, or whether he still wants to carry on relationship with the other party. Now, on the assumption that the breach is a pretty serious breach, which the innocent party intends to, terminate the relationship, the SDC does provide a mechanism for that innocent party to comply with, if I must say, and that compliance should be slavish if the innocent party wishes to employ the termination process under the agreement. The customer, for instance, who wishes to terminate due to a breach must give some notice, and the SDC provides that reasonable notice must be given. And I think that the word reasonable is used there is deliberate, because the reasonable notice to comply or to cure any breach really depends on the nature of the breach. So the developer might have a breach in certain ways, his obligations, and different obligations may carry different time frames in terms of curing any breach thereof. So the word used is reasonable notice to be given to cure the breach before any entitlement to terminate may arise. Whereas from the developer's side, the SDC provides specifically for a 30-day curing notice period. This is specifically in terms of non-payment, as well as any other breach. Any other breach of the customer usually relates to the customer's obligation to do something, which is not as complex as the developer's obligation to do something. The customer's obligation to do something could be, for example, like provision of certain hardware with certain specifications required to ensure the continued or the proper continued software development, or even provision of certain employees to be available for say, user acceptance test. So all these are not really complex obligations on the part of the customer.
Yeah.
Hence, there is a more definite period for curing that breach in the event of customer breaches. Yeah. Of course, all this the SDC does not discount the fact that there could be common law rights of termination as well.
Right.
And I'm not going to that for the moment.
Okay, that's fine. So, I mean, we obviously can't go into very specific details given the time we have. But now moving on, right? So we have talked about a little bit about what the contract provides in the event of breach and the remedies available for the innocent party. Now moving on, assuming the breach, the dispute cannot be resolved, right? What mechanism does the contract provide if parties wish to resolve the dispute, right, legally, right? Is there a dispute resolution process provided?
Yeah, there is. As a starting point, there's a provision for parties to try to resolve the dispute through negotiations. I very quickly opened the window for question and answer. And I think it's a question from my good friend, Dr. Nasim, who has referred to clause 13. Asking if negotiation is a condition precedent to arbitration under this clause. I think Dr. Nasir probably knows a lot more than I do as far as this issue is concerned, but I'll try to answer that question. I think the answer is yes and no. Yes, because there has to be a request for negotiation, and that if there's an affirmative answer to that request, then parties are then obliged to go into negotiation. And there's a timeline, I think, provided for in the agreement, which is 14 days. No, if there's a request for negotiation and there's no positive response to it, then obviously there's no no need for negotiation, and therefore it doesn't become a condition precedent if the other party doesn't comply with the request for negotiation. So I suppose then one can then go for arbitration after that, and then the subsequent sub-clauses set out the fact that the arbitration will then go according to the AIAC rules, and it also provides for very important elements to the arbitration, like the seat of the arbitration and so on and so forth. And the seat of arbitration is especially important because it then governs how the arbitration is going to be governed and supervised subsequently, and by which courts.
Thanks, Guan Huat, for answering that question as well. We have, I think, time. Actually, we've run out of time, but perhaps if Chelsea thinks it's all right, we can answer another question. So this is a question from Haslan Othman. He says in the case of software development which involves more than one phases releases, the warranty should have started from each acceptance test go live. Adeline, do you have any views on this?
It really depends on what kind of software you're developing. If your software is modular in format, so let's say you have one part for billing and invoicing, for instance. If that is the whole of your initial software, then you will able to do the acceptance test in one go. But if you still have other stages to add on, let's say a CRM to your invoicing software, and that is already in your contract itself, then yes, I think the warranty should start from the acceptance test for each phase or each release, depending on how you have put down the structure of your phases for your software development. So it's really up to the parties to agree on how you want to structure this, and whether or not you want to do an acceptance test for every phase, or you can do a warranty for the entire acceptance test as a whole.
I see. Okay, thank you, Adeline. Over to you, Chelsea. Thanks, everyone. Thanks, panelists.
Thank you all for joining us. And so what we'll do now is we'll invite for all of our other panelists that are here, we can run through the last questions that we have on that are on the screen. So I'm just going to click answer live so all of the attendees can see all of the questions. Just answered the last one, so I'll go ahead and clear that, and we'll address these questions. And if any of the other attendees, if you have any other questions, please feel free to post them. So we'll start with the first question, and whoever feels like answering the question, please go ahead and unmute yourself and I'll let you answer. So the first question is it true that the developer is obliged to get the client's written consent for every subcontract pursuant to clause 16.3 subcontracting? So are any of our speakers from any of the sessions, just go ahead and unmute yourself if you would like to answer this question. Perhaps what I can do to make it easier, let me see if I can bring up and show this on the screen. One second.
Hi, Chelsea. I'm looking at the clause now, clause 16.3 of the SDC. And basically it says that, yes, written consent will be required every time. However, with the usual caveat that the consent is not to be unreasonably withheld.
Thank you. And so I don't know if you want to expand on what you think unreasonably withheld would mean, perhaps, because I think that might be why they're asking this question.
I would think, I mean, basically three scenarios, I think, where, it could be perhaps be reasonably withheld. One, if you want a particular developer, if it involves something involving the aesthetics of a website and you want a particular person to be doing it, you may not be agreeable to having it subcontracted. In this regard, I'm thinking of developing my own software which has been developed for me, where I wanted a particular individual to be developing it. because of the user interfaces that are involved, and you do not want someone else doing it. So one could be that personal touch that you want from that person. The other, of course, I guess, can relate to the financial or the experience of that subcontractor, and you may not want a subcontractor who is financially tricky or or with insufficient experience, because that would clearly affect the progress of the development.
Thank you. And now moving on to so Dr. Naseem had a second post to his question, which was irrespective of the negotiation portion, why not encourage the mediation, preferably under the auspices of AIAC? So perhaps I can answer this because it's was an AIAC sort of decision of when we were looking at it, is when we were looking at the software development contract and the timelines normally under these type of contracts, and in looking at how mediation is treated currently in Malaysia, we have noticed that quite a number of times when there is a mediation clause in contracts that requires mediation, it brings to the point you made in question one, was the condition precedent argument, that currently in Malaysia, we haven't seen parties be too keen on mediation yet. Now, this doesn't mean to say that if the parties want to go to mediation, they wouldn't be restrained from doing so. But under this contract, given that it's quite different than, say, a construction contract, the contract might be quite large, but we figured that software development might be something that could use the fast track procedures as well. So if you notice in clause 13, it also promotes the fast track procedures. But if the parties do want to go to mediation, there's nothing stopping them from going to mediation first and attempting to resolve the dispute, and then only would they come to arbitration. And then also I just wanted to add one thing to the, in terms of the acceptance test and the go live in the warranty period, if you actually look under the defects provision, so the developer would be required to address any of the defects during the acceptance test. So that's why the warranty period is after the acceptance test under this contract, because basically what it's doing is it's ensuring that after the contract term has finished and the customer has accepted the software, there would be a short term of warranty period that would cover the parties any type of issues that would need to be addressed by the developer. So now moving on to our last question. And if anyone else has any questions, please feel free to do so. Oh, yep. Daya, did you want to add something?
No, I just accidentally raised my hand. Sorry.
No worries. Okay, so our last question is, how do you mitigate a contract term where the vendor requires the developer to indemnify for damages, losses, claims, legal fees, third-party claims, et cetera, for breach of contract? So does any of our speakers want to take this one on?
I'll try to, Chelsea. I suppose in terms of trying to mitigate this particular effect of this clause, one has to look at the respective bargaining power of the parties, number one. And if you can't exclude it, you will have to try to limit the amount of compensation that's claimable by the customer. And of course, in the other scenario, I presume that as a software developer, you should also be adequately insured so that at least that insurance can be relied on for you to kind of be indemnified in case that you have to pay the customer certain amounts of compensation for any breach.
Thank you, Guan Huat. So I think with that, it does not look like we have any further questions. I would just like to thank all of our speakers today for joining us, as well as all of your comments and the assistance in drafting the SDC. And I would go ahead and open the floor if any of you would like to say any closing remarks before we close the session. All right. Well, thank you all for joining us. It has been a pleasure having you here today. And I will just say for those that were not in the initial part of the session who may have joined later, that we will be having a website up and running soon. We'll make an announcement on that. It will be sfc.aiac.world/tech. And we'll make an announcement on our social media pages. And for any of those who want to get a copy of the contract in the interim, feel free to email us at tech@aiac.world, and that's TEC@aiac.world. So thank you again, and hope you have a great rest of your day or evening to those who are in different parts of the world. Thanks.
Thank you, Chelsea.
Thank you, everyone.